many people. Robert Huff versus Scott Renner. On behalf of Mr. Huff.
Yes, good morning, Your Honor. Curtis Warner on behalf of Mr. Huff.
And on behalf of Mr. On behalf of Velo and Cascade Agent Solutions, excuse me, and Mr. Renner.
On behalf of all defendants, Scott Renner, Your Honor.
Your Honor, just the Cascade Solutions is not a defendant in this case.
Yeah, I see that. I apologize.
I
was just, no, I got it. I know it's not.
All right, thank you, Your Honor.
So I've had an opportunity to review the motions and responses, and so we set this out so that I could have more time because it was fairly voluminous. So if we want to go ahead and start arguments.
Absolutely, Your Honor.
Oh, wait, what? Go ahead.
Oh, no, go ahead, Your.
Go ahead.
I was just going to say, yeah, as the court knows, today is the date and time scheduled for the adjourned motion for summary disposition on behalf of the defendant. At the last hearing, we weren't exactly sure if the court had accepted to process plaintiff's motion for summary disposition at all relevant times. Defendants have treated this hearing as being both plaintiff's motions and defendant's motions. If there was any type of time limit, of course, we would waive. And I think all the pleadings related to the filings and the responses have been filed with the courts.
I think so. I think I have copies of everything. I think I read everything.
Yep. Your Honor, I think to really understand what's going on, it does take the amount of time, as you indicated that you took, to go through the pleadings. There are three main pieces relating to plaintiff's claim that defendants have violated the Michigan Regulation of Collection Practices Act, the MRCPA. We look at it in three distinct areas. The first being that a lawsuit was filed on a debt that plaintiff's position is that it was not due. Obviously, defendants is that it was. That defendants in this matter attempted to collect pre-litigation interest. Plaintiff's position that was not allowed. And then lastly, that when the state court action was filed, defendants filed in the name of the incorrect entity, and therefore in the pursuit in litigation that the debt itself wasn't due to. We believe that the facts and circumstances of this case are actually much more clear-cut than plaintiff would present to the court. The cases involved, as it relates, kind of going in the opposite order. Right party of interest is very clean. Anything dealing with a contract is a meeting of the mind. It's the intent of the parties. And in this case, it's very clear what the parties intended. Yes, a authorization for suit was very poorly written. It was changed immediately after. Based on the parties, based on the affidavits, based on the history of the accounts and so forth, very clear. Even when you read the affidavit, talks about consideration. There's been no discussion what consideration was there, because there wasn't any consideration. Even further, when you look into it, it makes reference, the authorization makes reference to for the party, Sun Homes in this case, would be liable for additional court costs, which again, wouldn't AAB be the one liable to Sun Homes? It's very clear from not only the writing, what the intent of the parties were, but even through the facts and the cases. There's a deposition where a question was asked. Unfortunately, the terminology used was not defined, certainly a lot of legalities, versus just a black and white simple affidavit that specifies what the parties intended for the agreement. Moving on to the interest, I believe in very well in our position that we have cases from the Eastern District of Michigan, the Western District of Michigan, actual written opinions, not to mention the history of that statute throughout the state, throughout thousands and thousands of judges authorizing it and allowing it, because the statute is very clear. If you don't have a contractual rate and it's for a contract, you can charge 5% prior to a lawsuit. Plaintiff in this matter has only one case to blank, which to bring the claim, and it's a random oral argument from a judge in Illinois referring to a different matter of someone charging the maximum amount of 7% versus, again, the 5% as was issued here. I believe the president involved with the interest, the statute, the reading itself is very clear cut. And lastly, and probably the most substantial piece, which is relating to the actual litigation itself and towards the contract. I would think that if you were to define the difference in beliefs between plaintiff and defendant, plaintiff's position is that we filed a lawsuit on behalf or for a contract. It is our position that we filed a lawsuit for a debt, an accumulated debt. It is plaintiff's position that the original state court action was dismissed because the debt or the contract and so forth wasn't due. Makes reference to a few statements made by the judge in that matter about it being the only contract that anybody knows of. Even within that, clearly, even in that matter, that's a fairly broad statement. And again, it's very clear from not only the order of the district court, but the appellate court as well, that it was dismissed for Sun Homes' failure to provide the responses to the discovery, provide the actual copy of the second lease to now plaintiffs in this matter. And as you read the decisions and you read the appellate structure, that is very clear what it was. It was plaintiff in that matter, Sun Homes, being punished for not being able to provide a copy of the lease.
Let's stop right there. Mr. Warner, because I read the appellate opinion and I read Judge Oakley's comment when he dismissed it and then the appeal stuff. And it appears to me that Mr. Renner is right, that is why they dismissed it. It's because you didn't have notice when it was set for trial.
Your Honor, so the Judge Oakley's opinion for the dismissal was based on the fact that from November 21st, 2016 through March 2nd, 2018, defendant's position was based, as it states in the pleading, on a lease with a term of July 1, 2010 through June 30th, 2011.
Right.
Now, when the appellate court gets the opinion, they affirm on that position, but also, as we raised in our brief, the appellate court, the Wayne County Circuit Court in this case, affirmed on a secondary position in which the court said that the defendant, Mr. Huff's summary disposition C-10 motion should likewise have been granted on alternative grounds. That is persuasive that there was an alternative ground is that, look, the defendant, Mr. Renner filed a lawsuit on a contract, maintained that position for a year and a half through litigation, that was the
contract. Tried to change it at trial. I mean, that's
right.
Tried to.
But you can't, the violation occurs at the time of the filing. I mean, think of it this way, and Judge Oakley brings this up. If you're not ready to roll on your claims, you shouldn't file the lawsuit. And that's what happened here. I mean, but for Mr. Huff's new employer having a legal service plan in which
but regardless, your request on the monies doesn't go back. I don't have the breakdown. Give me the breakdown of the request of the
Sure. Well, there's a $20 motion fee that was involved in the, you mean as the monies as far as what was alleged in the lawsuit?
No. The breakdown on what you're asking for now. You don't go back to day one on the law. My assessment was you didn't go back to day one anyway.
No, that's correct.
You did the appellate, which was what's the total amount that you're requesting?
$5,675. And the reason for that is that
I don't know why the front of this, I'm pulling up this front, the front of this file says 17,000. I don't know.
Well, that's because it's trebled. Under the
That's why. I got it. But no. I totally agree with you. I forgot about the treble damages. Yeah. So you're not even asking, even though your position is he was wrong from the beginning. They were wrong. They shouldn't have filed it. They, you know, it was dismissed the day of. You're really just asking for the appellate cost because because when it was dismissed, they should have just let it go.
That's one reason.
I got it. And that brings you around to this other stuff. Yeah.
Correct. And the other reason, Your Honor, is Mr. Huff was under a legal service plan. So he himself was not out of pocket. That was included within his employment.
Oh, okay. Okay.
So him retaining Kelly in advance check, that was employer paid. So we can't, I mean, there was no out of pocket cost except for the $20 motion fee. That
right.
He was responsible for.
Right. And so the total amount is the 17,085, which is trouble damages, and that's in that, and then filing costs on top of that.
Well, correct. And attorney's fees under the statute too, we would be entitled to petition if your court finds in our favor for the litigation of this matter. Which
Okay, go ahead, Mr. Renner.
Absolutely, Your Honor. And first and foremost, as it relates to the appeal, the time for requesting costs and so forth on that was during the appeal. It was requested. It was not granted. So anything related to attorney fees and so forth relating on to that, that's the time for that appeal to be done.
Our client wanted to appeal. Well, I think he meant attorney fees in this case, not attorney fees on the, so your position is that during the appeal, they asked for attorney fees and it was denied.
It was not granted. Honestly, I don't remember offhand, but there was the claim for it, as there always is with appeals.
And I don't think that prevents them from seeking it separately.
Even if it doesn't separately.
Response on that issue?
Yeah. Yes, Your Honor. There was a request
there's always a request, yeah.
for a frivolous appeal. The court didn't even rule upon it, and we didn't appeal the issue because our right to seek recovery is preserved. It's under the Michigan Regulation of Collection Practices Act. If the amount was granted, well, then that's our remedy, and then that is the monetary amount of money of the damages that would have been there, and then we'd be just fighting about a $20 motion fee before, right. Your Honor. So
right.
Even though that there was no ruling at all, I mean, there was even no mention of it, our claims for the attorney's fees as the damages are still preserved under the Michigan Regulation of Collection Practices Act.
Okay.
Of course, Your Honor, we would argue.
Continue, Mr. Renner.
Of course, Your Honor, we would argue that an experienced appellate attorney, as specified, would certainly bring it and would file the motion for costs after the appeal. My office, clearly not the experienced appellate attorneys as the plaintiff's attorneys were in the state court action. We even do it and we get it every time we are successful on appeal as well. But notwithstanding, had plaintiff in the original case, Sun Homes in this case, had they never provided a copy of the most recent lease, it would have gone to trial. And of course, this is just an opinion, we would have been successful. They keep saying that we were filing on this original contract originally. No, we did not have a copy of the contract. So when we filed the lawsuit to establish a relationship between the parties, we provided documentation relating to the relationship. It's a very common practice. If you don't have the most recent of something, provide an older one. So at least they can't say, I don't know who this is, at least as much as one can. It is our position that we argue that this lease was available the entire time. And even notwithstanding, I mean, the plaintiff in this matter keeps saying that for this whole period we didn't, but it's just in that period we didn't have the lease. So he keeps making plaintiff keeps making the argument that because we attached an older lease to the complaint, that there's no way that we can argue that money was due under something else, which is asinine. It is evidence that establishes the relationship. Evidence is of establishing that even though we can't find this other contract, and we have to specify the terms, look at what he agreed to before. So most likely the contract of the renewal, and it's not actually a renewal to new contract, of course, but just renewal is just what you think of when you're extending something that's in place as it relates to Mr. Huff. When you do it, here is evidence of what was there. But because Sun Homes was able to locate the lease at the last minute, and because of a number of other factors on behalf of the plaintiff, the court made a decision. We, of course, didn't agree with it, but it is the court's right to make that decision. And not only did they have the right to make it, we had the right to appeal it as of right, of which Sun Homes lost. That's why appellate decisions, and that's why you can appeal a decision. That's why if you want costs related to the appeal, you have the avenue at that time to request it. Otherwise, every single person relating to an attorney, or every attorney at some point, every attorney collects a debt. It's part of their practice in some form or fashion. It opens it up. How many avenues can they have to collect their attorney fees relating to this? Not to mention, simply losing a state court case is not a violation. That's plenty of precedent, especially as you relate it to the FDCPA that makes that statement. It's very clean cut. But here, in the end, the debt was due. How can there be a violation of the Michigan Regulation of Collection Practices Act if the debt was due? Now, again, when we talk about the debt being due, we're saying that the debt that we filed for, that had the final statement of security deposit listed on it, that made all the references to the dates and the contractual length and the amount of time and the period of time and future rent, everything else related to that, was exactly what the contract that we were unable to produce to the last minute. Just because you lose a contract and you don't have a copy of it does not provide a basis for you to never pursue that action. A contract does not have to be in writing as a general concept. Of course, on the statute of fraud, some of those situations don't play out. But simply because you don't have the contract, or it did not that you don't have location, or there wasn't a physically written contract, does not make a debt, which is what we sued for, not due. That's even why when you file for breach of contract. And then if for some reason that contract claim isn't there, you have your account stated claim. If for some reason that's not there, you go to the unjust enrichment claim. They're all pled in the alternative in case the prior one isn't there. In this case, if we talk about the debt, there's no argument that the debt itself, that amount of money was not due to Sun Homes. And simply because they have this position from day one, it's creative, but it simply would make how many cases in this state, how many lawsuits, there's no precedent, there's no factual basis, there's no statutory strength behind stating that if you attach an older agreement when you don't have, or you can't locate the newest agreement, that means you're suing under that other contract, not the one that you can't locate. And that is what plaintiff in this matter is trying to claim.
But if you can't locate it, and so at the time of trial, you get dismissed because produce it or you can't use it and you can't locate it and it's dismissed, then why isn't it, why aren't you liable for the costs of the appeal? If you know that you didn't have the document and you're appealing saying that Judge Oakley is wrong, apparently, that you didn't need the document.
Our argument was that dismissing a case with prejudice as a punishment without it being specifically related to the facts of the case is the harshest sanction as stated in many decisions. And that under the circumstances,
except that that's not when you don't comply with discovery requests under the law in the state of Michigan, that's what you get.
We did comply under the discovery rules. You have to produce for lack of a better term, everything you can have and everything you can locate. And you're also obligated in Michigan, unlike some other states.
But you weren't proceeding in this lawsuit saying that there's some ulterior theory. You were saying it was based on a contract that
Correct.
You didn't have. You keep talking because about, oral agreements and stuff like that. When you sue on a contract, that's the play. That's what you have to produce for a trial. You can't change your theory of your case the day of trial. So you're not mitigating your damages when you're appealing a case that clearly you were prevented from, because that's what you sued on. You sued on the contract. You didn't sue on some ulterior theory.
Your Honor, from day one, we always took the position that there was a contract. Just because I don't know any legal basis of which, if a contract is lost, that you can never pursue that debt. That contract, if you lose a copy of a contract, that it doesn't exist. That's why you have the trial. That's why you have the testimony. We, in our discovery, couldn't produce it because we didn't know where it was. We couldn't find it. Things get lost, unfortunately. Then, under our obligation, and by ours, I mean Sun Homes, of course, we continued to look for it. And as required by the court rules,
you've never found it.
No, we have, Your Honor. That's what we produced, because we produced it, and it was we finally.
Oh, that's right. That's what Oakley said. A day late and $1 short, because you can't use it. But that's the whole point. When you have discovery rules, and you're told produce it or you can't use it, that doesn't mean that you get to dismiss your case and refile. You're stuck with it. So he is right that it's with prejudice, because when you don't have something, then you should have on your own gotten out of it instead of trying to go towards, when you're walking into a trial that you can't use something that you didn't produce. So why you thought you could show up the day of trial and produce it is beyond my comprehension. And I don't know what Judge Oakley said to you guys. I would have made it crystal clear, because I say this all the time to when somebody's saying, well, they didn't give it to me. And I say, then they can't use it at trial.
We never got to the trial.
I speak that to a couple of specific attorneys that come to mind all the time, that I say, then they can't use it. Then they're precluded from using it. Then we're going forward without it.
Your Honor, we never got to the trial.
I understand that, because
we didn't use it at trial. We use it to defend their motion for summary disposition.
Right.
Yeah, and we produced it the moment we had. Our alternative was, this is being punished for doing what you had to do.
Mr. Warner, response.
Thank you, Your Honor.
Technically, I should have started with you. It was your motion, but that's fine. He jumped.
There's dueling motions.
I don't care if it's, pardon?
There's dueling motions, so
he's got his motion to dismiss, so it doesn't matter. But anyway, go on.
Thank you, Your Honor. There's a lot to unpack here. First of all, it seems that Mr. Renner is admitting to a pervasive and improper debt collection lawsuit practice, where they find a contract, whatever the contract may be, they slap it on to the complaint and they roll with it. And the reason why that's so concerning is that the majority of these—
I have to object, Your Honor. When did I make any statement like that?
He didn't interrupt you. Please don't. You'll have a chance to respond. Go ahead, Mr. Warner.
I apologize, Your Honor. I apologize.
Thank you, Your Honor. Is that a lot of these debt collection cases result in a default judgment. In this case, Mr. Renner knew that they didn't have the lease. He's now admitted that. He admits that they just went and they filed it, and they filed it in the wrong court. They started off in the 26th district.
I saw
the reason why they did that, and which was concealed from Judge Oakley, is that in the separate contract, and it's not a renewal, the first contract, the 2010-2011, was Mr. Huff and Ms. Wozniak as co-tenants. The second later produced 2011-2012. Mr. Huff was the signator, but there was also Scott Nichols.
Right.
They hid from Judge Oakley that they were collecting monies from Scott Nichols. And when he stopped paying, right before the statute of limitations, they go off and file where Scott Nichols lives in the 26th district court and not even naming him. So we have a concealment that they were collecting from somebody else who they felt were responsible on this. The contract itself is the contract. Terms change. Mr. Huff obviously would have had a co-indemnification claim, a cross claim against Mr. Nichols if the right contract was brought. He would also have other defenses. And especially that he had given notice to Sun Homes that he was leaving. And you see this in the shifting sand throughout this litigation that went on for over a year and a half on the wrong contract filed. Now, Fisher Sand and Gravel, it is a Michigan Supreme Court case that says if there is a contract, that is what you have to sue upon. Michigan law, over 100 years old, says you are bound by the terms of the contract. That's it. You can't go sue on other contracts. You can't, and Fisher Sand and Gravel says you can't sue under alternative theories, such as an account stated or an open account. Those are not there. And in fact, under Michigan court rules, those are procedural traps, because if there's an affidavit and there's not a counter affidavit and just an answer, the debt collector is going to file off a quick summary judgment motion stating, well, you never produced an affidavit. It's a trap for bless you, Your Honor.
Excuse me. Thank you.
It's an unwilling trap for pro se litigants. I mean, this is a very bad and deceptive practice in of itself. You sue on the contract, the person can look at it, usually their statements. In this case, all the statements had shown that the debt was completely paid in full. That is where the violation occurs. The moment that the complaint is filed is when it occurs. You can't unring the bell on that. As far as the second count, the improper addition of interest, it is a straightforward claim. The Chief Judge of the Northern District of Illinois, addressing Mr. Pilarski's claim, who is another client of Kelly and Vanchek's. He used to be a member of Harbor Club in Belleville. And so under Michigan, the judge there was looking at Michigan law. And she looked at the statute of the usury statute, of which the defendant said they relied upon in adding the 7% interest. Well, first of all, yes, 7% is the maximum if there is a writing. And here there has to be a writing. This is the Landlord Tenant Act of Michigan that governs it. There has to be a written lease if there's a term of a year. And so she looks at.
But let me ask you a question.
Sure.
Even if I found that there was no that you're wrong on the pre-litigation issue, on the pre-litigation interest, it's irrelevant. That's not really what this is about.
Correct. It's not. It's just one of the other.
It's kind of a throwaway red herring argument, isn't it?
No, Your Honor. It's actually to preserve and to correct Michigan law. Since 1991, when the Judgment Interest Act was.
But what I'm saying is, if they didn't have the right to sue on the debt, regardless of whether it was $1 or $50, whether there was interest on it or not, really isn't the issue here.
That's not the meat. Correct. That's not
the meat and potatoes. If you want to make that argument, do you know what I'm saying?
It is. I'm just preserving it in there. And if this goes forward on any appeals, it's an argument that's preserved. I mean, until Friday for 75 years, the governor believed that they.
We're not having that conversation.
Well, the only reason, Your Honor, the only reason I bring it up, there's two folds. First of all, is that laws can stay on the book without being challenged for a long time.
I understand that.
And the second one is that the court specifically stated in their opinion, a 2020 opinion, citing another 2020 opinion, that when there is a statute that specifically addresses the issue, that controls. So our argument, stated in the briefs, is the judgment interest controls. If it's over 25%, it can change it down to 13.
Sure.
If there's no interest, there's no interest, because that's the law of contracts in Michigan. But upon the filing is when you get the interest.
I understand what the argument is.
Thank you.
I just wanted to know whether you really thought it mattered, but fair enough.
It doesn't add anything. It's just preserved for any potential appeals.
That's fine.
And to bring up, hopefully to get the law corrected, because it does kind of matter in Michigan.
No, I understand. I understand.
Thank you. And then on the third one, the Account Adjustment Bureau, the affiant Ms. Boink, who was the corporate representative of Account Adjustment Bureau, was later deposed. Under Michigan law, her later deposition testimony is what controls, not the affidavits. As a corporate representative, she testified on behalf of Sun Homes is that the account is transferred. The title and the rights is to transfer. The proper party in this case, that in the state court case that was filed against Mr. Huff, was Account Adjustment Bureau. Mr. Renner doesn't even have a retainer with Sun Homes when he testified. What happens is Sun Homes hires Account Adjustment Bureau. Account Adjustment Bureau enters into the retainer agreement with the Vello Law Firm. And that's even missing from the court record. That wasn't disclosed to Judge Oakley. And this also lends into the issues of Mr. Huff's counsel, John Ivanchek, of trying to figure out why can't he get these documents that he's asking for in discovery. And the reason is it's not Sun Homes that's dealing directly and driving the litigation. It's Account Adjustment Bureau. And this case not only addresses these issues, but it also now, and also given what Mr. Renner has stated, should draw a great concern from the bench of these mass volume collection practices. For these reasons, Your Honor, that we stated here and within our brief, we believe that the plaintiff is entitled to the damages of $5,675 for the appellate, for the having to defend the appeal, the $20 in cost, and on appeal costs are costs. They're paper mailings, they're not attorney's fees. And we request those to be trebled for a total of $17,085, plus the ability to petition this court for attorney's fees and costs under the Michigan Regulation Collection Practices Act. If there's no more questions, I will rest, Your Honor.
Okay, Mr. Renner, any other response?
Yes, Your Honor. I would just like to make a few corrections. Here in this matter, just kind of, I guess, going in reverse again. I have no record, and neither do the pleadings. I ever said we don't have a retainer agreement with Sun Homes. I was asked at a deposition about a topic and a question that I had no chance to rely on. I said, I don't know if we have one. It's very clear cut. To argue anything otherwise is simply inappropriate. Again, the interest statute, again, the statutes speak for themselves. This is pre-litigation interest. A judgment interest statute doesn't conflict the two, doesn't conflict. The judgment one says, if you don't have a contractual interest rate, here's what happens once you have a contract. The one that we utilize for pre-litigation, and as the written opinions of specifically on point cases in Michigan provided the opposite, that as there wasn't a writing, that these ones would apply until some other one would. And the moment a judgment enters, the interest rate becomes the 1.669, or as it changes every 3 months. Anything relating to something being preferred that the law shouldn't be is not a defense. It is what the law is. So as you relate to rebuttable presumptions with account stated and so forth, that's judges. And how often do judges, they factor that in. They know pro se, they give pro se's great deference. But we're lawyers. We're supposed to follow the law. We're supposed to provide all possible avenues for our clients, vigorously represent them. So as it relates to the account stated and so forth, nothing was ever hid from the judge here. An incompetent attorney is not a violation of the act. We didn't just slap a contract on. We sued for a debt, a contract that was lost. I still maintain that the debt itself was due. Even at this moment, forgetting about what case was sued on and everything else, the debt was due. It's still our position that we sued on a debt and then tried to establish through it. Now, yes, if you don't provide it, you can't use it at trial. Absolutely. But at the same time, you are required to still supplement your discovery. And if you don't have something and nobody has it, and needless to say, what we had was exactly what we had always said we had. But notwithstanding that, you go to the trial and you have the witnesses, and the judge makes, in this case, the judge makes the decision on whose testimony they believe more. Somebody saying that they didn't sign one, or somebody saying that they did. And that's for the judge to decide. And here, because the judge felt, and based on a number of facts, that Sun Homes had not taken the litigation as seriously as it should, and that's just a nice lighter way of saying it.
Hold on one second. Hold on one second. I apologize. My staff was trying to reach me, but I didn't get them. Go ahead.
Absolutely, Your Honor. Excuse me. But the individual contract, it was the debt. That is what was sued on. Now, I absolutely concur. We disagreed with and by we, I mean Sun Homes. Had Sun Home retained a different attorney to do the appeal, but it was the appeal. It's separate from the appeal. We lost. We didn't do a good enough job for our client. We accept that. But it's still based on whether or not a debt itself was due. And we sued on a debt. They're saying that we sued on a contract, but simply because you lose a contract does not mean that the debt itself wasn't due. Sun Homes has been punished. They have been punished. The district court judge dismissed the case with prejudice, and the debt could not be pursued because it's been dismissed. Otherwise, technically, that debt would still be due.
Mr. Runner, I've heard enough. I've read all of the briefs and responses, the motions, responses, the voluminous. I have 2 files that have hundreds and hundreds of pages of documents that I've spent an enormous amount of time reading through. And at this point, I'm ready to make a decision on this. And at this point on first dealing with the defendant's motion to dismiss, I'm gonna deny the defendant's motion to dismiss. On the plaintiff's motion for summary disposition, I'm gonna grant summary disposition on all counts except for count 2. I'm not addressing or dealing with the pre-litigation interest issue. I think it's academic, and I'm not going to get into that. And I haven't researched the law, and I'm not comfortable with what's been presented to me on making a finding of summary disposition on that count. I am going to find summary disposition on all other counts and grant summary on all of the counts, including the trouble damages and the violation of the MRCPA. And with that, counsel, Mr. Warner, if you file an order to that effect and email it over, I will sign it. And then I will entertain a motion for reasonable attorney fees. At which time I'll hear that motion.
All right. Thank you, Your Honor.
All right, you go ahead and send it over. Page, is it civil 34
dc@gmail.com.
dc@gmail.com.
Your Honor, I know you've made your decision, and I'm not attempting in any form or fashion to have you change it, but I'm wondering if you could elaborate just for the purposes of the litigation and perhaps future litigation as towards specifically what violation.
I'm adopting the brief.
Okay, specifically the brief.
The plaintiff's brief.
And also, since there has not been any discussion as towards the requirements and standard for treble damages, if there could be any elaboration as towards what and the stand and so forth, that why
a violation. Mr. Warner, if you want to respond to that, because a violation.
Sure. It's willful.
It's I'm sorry.
It's willful. He
It's
did
willful.
it.
That is the requirement for trouble damages. It's just a willful act. Since I adopted his brief, I'm making a finding that the actions by the defendant were willful.
Okay, thank you, Your Honor.
All right, submit the order, Mr. Warner. I'll sign it.
I will. Thank you, Your Honor.
All right, you're welcome.
Thank you, Your Honor.